Good morning and welcome to the latest in our In-House in Focus seminar series. I'm Simon Pedley, a partner here at Mills and Reeve, and I have the pleasure to be chairing this session. You will be addressed today by Alex Newman and James Shield, respectively a partner and senior associate in our intellectual property team, and they're going to be talking about generative AI and the intellectual property risks when using those tools. And they've asked me to stress that it's about those infringement risks when using it, not any of the other many risks that you may encounter when using AI, for instance, using it to draft your legal advice to your organizations, which might well be considered a foolish thing to do. But it's not about that. This is about the infringement risks. And I'm pleased to say, of course, there's nothing remotely artificial about Alex or James's intelligence. It's real, organic, additive-free intelligence that they're going to be delivering to you today. And I'm at least 90% sure they've not used ChatGPT to write this talk. They'll correct me if I'm wrong. We've already had a question asked, will the recording of this presentation be made available? Yes, it will. The presentation, the slides, and the recording will be made available afterwards. Do ask any questions you want, put them in the Q&A box, please, rather than chat or anything else, and I will monitor those and collate them and ask what I can at the end. If you can, please put your names down when asking the question so that if we don't have a chance to get to your question today, then we can follow up. If you do put your name on, I won't mention your name when relaying your question to the panel later on. And if, I say this from long experience of these things, if you could have a question and you can tie it to a particular slide and just put that little bit of context in the question when it may not otherwise be obvious, that makes it easier to address the questions to the panel at the end. At the end of the talk, there will be an opportunity which we would love you to take up, please, to fill in a feedback survey and to give us suggestions for future talks. And there is going to be a slide just bigging up our next seminar in this series afterwards. And I won't give you any spoiler alerts now as to what it's going to be about. You have to wait till the end of the seminar to find out. But without any further ado, I'm going to hand over to Alex and James. Guys, off you go.
Thank you, Simon. Let me start with a statistic. According to research, more than 4 million people in the UK have used generative AI for work, despite that only 23% of respondents in that survey believing that their employer would approve of them using it for work purposes. This is according to research published by Deloitte in July 2023. One of the questions that arises is as follows. What are the risks for businesses and its staff when using Gen AI? You have heard about the growing capabilities of Gen AI, and as we said in our invitation to this event, for example, how it's used for slash spending on content generation. Today, the purpose of this talk is to enable you to better understand the intellectual property risks for commercial users of Gen AI tools and ways in which to mitigate those risks so far as possible from an English law perspective. We're going to do this by first discussing the background, second, moving on to discuss the infringement risk and mitigation piece, and third, finishing with a discussion of the current summary and potential future developments with respect to IP. Before we turn to those three topics in turn, I want to mention two additional points. First, a very special thank you to one of our training solicitors, Ella Moss, for assisting with the preparation of today's presentation. And secondly, a brief word on the topics that we are not covering in today's talk. Today is not secretly a full-day lecture on Gen AI, which means that there are various topics and issues that we will not discuss today, as Simon mentioned. The issues are multiple and varied, for example, from data protection, cybersecurity, to bear traps in the drafting of T's and C's, etc., in the context of Gen AI. We plan to do, as a firm, other talks as part of this series on Gen AI, so please do get in touch in the feedback as to what issues around Gen AI management you would like us to cover in the future. So first, the background. So in summary, Gen AI is a subtype of artificial intelligence. Generative AI can create images, computer code, audio, and text. I like to think of it as comprising of 4 different asset classes. First, it has the data set on which it is trained, which has been trained. The technology underpinning generative AI is exposed to large data sets, including, for example, a vast number of websites and books. Secondly, you have the Gen AI tool itself. Third, you have the inputs, i.e. the prompts entered into the GenAI tool by the user. And fourth, you have the output generated by the GenAI tool from the inputs, such as the images, computer code, audio, and text that I mentioned earlier. Let's amplify that a little bit more by talking about the obvious example of GenAI that most people have heard of, ChatGPT. Others include Gemini, which is previously called Bard, which is Google's own AI chatbot, or Copilot, which belongs to Microsoft. On the more non-obvious end, there could be bespoke arrangements between a commercial user of GenAI and a developer, particularly where there's a specific reason for utilization of GenAI to generate specific sector content. Okay, so moving away from the more technical primer, the slide refers to the ongoing Getty Images and Stability AI High Court proceedings in the UK, which were issued in 2023. It is an example of first, of a GenAI tool. Secondly, how developers of GenAI tools are starting to face legal action in the UK. And thirdly, it is an example of the spectrum of IP rights potentially involved in relation to GenAI. So first, what is the GenAI tool in this case? It relates to Stability AI's deep learning artificial intelligence named Stable Diffusion. Stable Diffusion is alleged to have been trained on millions of images from Getty Images websites. Stable Diffusion generates synthetic image outputs in response to commands entered into by users. In other words, a user tells it to produce certain images from text and image prompts, and then it produces photos from those text and image prompts from the user. The judge, in the context of recent summary judgment application, says as follows about what the proceedings cover. She says, in broad terms, the claimant's complaint in these proceedings is that the defendant has scraped millions of images from Getty Images websites without the claimant's consent and used those images unlawfully as input to train and develop Stable Diffusion. Further, that the output of Stable Diffusion in the form of synthetic images accessed by users in the United Kingdom is also itself infringing in that it reproduces a substantial part of the copyright works and or bears the trademarks. So the proceedings are for copyright infringement, database right infringement, trademark infringement, and passing off against the defendant, who is a developer and open source generative artificial intelligence company. We're not going to go into more details of this case at this stage, but the case is a useful reference point for our purposes today as to the risks facing developers of GenAI tools in the UK. The question for our purposes, as mentioned earlier, is what risks face commercial users of GenAI tools in the UK? And on that question, I will now hand over to Alex.
Thanks very much, James. Hi, everybody. Yes, so as James was saying, a lot of the focus on IP infringement risks associated with the use of generative AI to date has been focused on the risk for developers of AI tools, particularly the lawfulness of how the AI tool has been trained, whether it's used unlicensed third-party content, and the liability of the developer in relation to the use of the outputs of the tool. So, for example, does the manner in which ChatGPT has been trained infringe the intellectual property rights of the myriad of third-party content owners which the tool has been trained on? Is Stability AI liable to the owners of the copyright in the content which it's been trained on, both in the context of the training of the tool and also in the context of the use of the outputs of the tool resulting from it's being trained on that third-party content? And the IP lawyers amongst you will also be aware that there's been an awful lot of noise and an interest on a worldwide basis in relation to issues associated with inventorship and can Gen AI tools be inventors for patentability purposes. But the reality is that a lot of that noise and a lot of those cases are of relatively academic interest to most commercial end users of Gen AI tools. They're just not issues which are typically going to bite or be too relevant. Pretty relatively little attention to date seems to have been devoted to considering and assessing the potential liability of commercial end users for intellectual property infringement, both in the context of the commercial end users' use of the outputs of Gen AI tools and also their role in the actions of the tool itself, the work the tool itself does, how it operates, and whether the manner in which it operates constitutes intellectual property right infringement. So that's what today's session is focused on. And Simon got a little bit wrong in his opening when he said that we hadn't asked any GenAI tools for assistance in putting this training session together, because we thought, what better way to start a session on infringement risks associated with GenAI than to ask GenAI about those infringement risks. So we asked ChatGPT, or more accurately, we asked the Bing implementation of ChatGPT, because that was what our risk and compliance team confirmed to us that it was okay for us to do. I'll come on a little bit later on to talk about internal policies associated with GenAI, but it's important that everybody complies with those policies. Now, we were originally going to present today, we're going to present basically what ChatGPT said, and then afterwards tell you this is what ChatGPT said. But we had a little bit of an issue with the outputs from ChatGPT, both in terms of its completeness, its accuracy. We felt it conflated some issues. We felt it missed some important points. So we didn't want you to think that ChatGPT's work was our work. So we're telling you in advance what ChatGPT said before we'll then go on to tell you, do a bit of a deeper dive on the aspects which we think are most relevant from a commercial end user perspective. So you'll see on the slide in front of you, there are 5 kind of buckets of risk which ChatGPT identified in this context. The first one, copyright infringement, will come as no surprise. Specifically, what ChatGPT said in relation to copyright infringement was that if the AI's training data includes unlicensed content, this could potentially lead to legal issues. We've already alluded to that. We've already mentioned that possibility. We think that what ChatGPT was getting at here was that if unlicensed content has been used to train the AI tool, and the AI tool then creates outputs which constitute substantial reproductions of the unlicensed training data, then that can create infringement risk. That's an obvious risk which James will come on to talk about in a little bit more detail. ChatGPT also mentioned risks associated with the ownership of AI-generated works. The reality, and again, we'll come on to talk about this in a bit more detail, is that the terms and conditions of use associated with GenAI tools will typically allocate ownership of any IP arising in the tool's output. Quite often it will allocate ownership to the user rather than keeping it to the tool itself. But there are some risks associated with ownership of outputs which are non-obvious, but nevertheless very real risks, which we'll come on to talk about in a little bit more detail. The third bucket of risk, unlicensed content in training data. We think what potentially ChatGPT is talking about there isn't necessarily risks associated with the use of the outputs, but risks both for developers of AI tools and risk for users associated with the actual act of training and the use by the engine of third-party content in answering questions, even if the output of the questions which are asked don't themselves infringe third-party content. So it's the process of answering the questions, the process of training, then answering the questions, and the risks associated with that. Liability for harmful outputs, we thought, was ChatGPT getting confused. It wasn't talking about intellectual property infringement risk when it came up with that answer. Again, a lesson to not just treat anything you get from GenAI as gospel. It's a starting point which needs to be subjected to appropriate scrutiny. And the final bucket was in relation to end user license agreements. Yes, as we've said, end user license agreements will allocate risk associated with IP infringement risk, and that needs to be looked at, particularly when specialist tools are being used. And we think we can rationalize and simplify actually a lot of what ChatGPT had to say about end user IP infringement risk, hopefully put it in a more meaningful context for commercial end users. But before we address the infringement position, it's probably more appropriate and helpful to cover the starting position, which is associated with the subsistence of intellectual property rights in GenAI outputs, and also the ownership in relation to those outputs, because only when you properly understand the subsistence and ownership position can you really get a handle on and understand what the infringement risk is. So James, I'll hand over to you now to talk about some of those risks associated with outputs, but first, subsistence and ownership.
Brilliant. Thank you, Alex. So Alex just previously mentioned that IP risks for end users of Gen AI tools in the UK relate to, for example, ownership of Gen AI works and in relation to unlicensed content in the training data. As we saw in the Stability AI case, there are potentially many different IP rights that subsist and can be infringed in the context of Gen AI. To illustrate the issues there, I'm going to focus on copyright and can't necessarily cover all of the issues in the time available. But let's start with the data sets. You will recall from earlier that the technology underpinning Gen AI is exposed to large data sets, for example, vast numbers of websites and books. Those works could be capable, for example, of copyright protection and may not lawfully be used by the Gen AI tool, even though they exist or are used in the dataset, and may not be owned by the Gen AI tool or the developer. The material, therefore, may well be unlicensed, and this is the complaint in the Stability AI case, i.e. that it has used images unlawfully to train and develop stable diffusion. Let's now consider the position with respect to outputs. Who owns the copyright in the output? Is it the user? Is it the Gen AI provider? Or is it the Gen AI itself? The best analysis that we have is that the copyright in the output would be owned by the Gen AI provider. UK law provides protection for what we call computer-generated works, subject to meeting the originality requirements for copyright. So Section 9.3 of the CPDA states that in the case of literary, dramatic, musical, or artistic works which are computer-generated, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. Now, the English courts have considered the scope of Section 9.3 in the context of video games in the case of Nova Productions Limited versus Mazuma Games Limited, which was affirmed on appeal in 2007. And in that case, it held that the developer was the author of the works and not the individual player of the game. Those of you who may want to play devil's advocate could say, though, that this has not been tested in the context of Gen AI. So there may be scope to say that the user is the owner of the IP in any Gen AI outputs. So let's explore that. And the answer is maybe. It will depend on the creativity of the user in its inputs and whether the output requires some form of significant human intervention. If you wanted to continue playing devil's advocate and say that the output could be owned by the Gen AI tool itself, as Alex mentioned earlier, the answer is no, probably not. And certainly in the case of copyright law, it would currently be prohibited under the CPDA because an AI machine is not a human and therefore cannot be an author for the purposes of the CPDA. In practice, though, the ownership position is likely to be governed by the terms and conditions, and the importance of end user agreements is therefore very important. For example, the ChatGPT terms and conditions, which is subject to Californian law, say that as between you and OpenAI, and to the extent permitted by applicable law, you, A, retain your ownership rights in the input, and B, own the output. And then it goes on to assign those rights to the end user. Therefore, the user, in that context, owns the IP in any outputs. If that's the case, though, what happens if more than one user generates the same or similar or duplicative content? Now, ChatGPT also has a provision related to this, and it says about similarity of content. It says, due to the nature of our services and artificial intelligence generally, output may not be unique, and other users may receive similar output from our services. Our assignment above does not extend to other users' output and any third-party output. So it may be the case that the first user owns a copyright in the work, but the second, third, fourth, fifth users, and so on, do not. And there's a question mark over whether subsequent outputs, which are effectively duplicative, meet the originality requirements under Section 1.1 of the CPDA. In the alternative, though, it may also be the case that the users own the copyright in the respective outputs, even though they are virtually identical. Let's hold that thought there for now. And as a very brief aside and for completeness on inputs, Just remember that, for example, copyright could subsist in the inputs that a commercial user uses in things like ChatGPT. And ChatGPT's terms state that the user is responsible for all input, and it represents and warrants that it has the rights, licenses, and permissions required to provide the inputs to the services. Further, remember that inputs could include confidential information, and confidential information ought to be kept, as you would probably expect us to say, should not be inputted into a GenAI system and should be kept confidential. Okay, moving on from the aside, let's build on what we've been talking about and consider examples in the time available of some of the IP infringement risks for commercial users of GenAI in more detail. Next, we're going to talk first about the most obvious IP infringement risks and work down through to the less obvious risks. Let's start with output. An obvious example would be if the output from the GenAI tool replicates a substantial part of a pre-existing copyright work contained in the training data of the GenAI tool. Building on that, imagine an exact copy of a copyright-protected photograph produced by the GenAI tool, further to an input from a user, and its subsequent use by the user, such as offering copies for sale, posting online, etc. That could amount to an infringement by the commercial user, and the owner of the copyright in the photograph may have a cause of action against the commercial user. We've discussed previously that in other examples, the IP infringement risk is not confined to copyright. Database right infringement is less obvious than copyright in the context of a commercial user, but it may be likely that trademark infringement and/or passing off could occur if the output also included trademarks or logos. Moving now to the more non-obvious examples. Imagine as an input, a law firm requests that a GenAI tool produces a thought leadership piece about a new Supreme Court judgment and publishes it online. What if then a second law firm makes an identical request and receives an identical response and posts it online? If the users are assigned ownership of the output by the terms and conditions, is the first user entitled to sue the second for infringement? And what if the second user can't prove that it generated the output via the tool independently? If it can, there would be no infringement of the first user's work. But what if the first user then licensed the piece to the world for free? Can the second user still sue third parties who copy the work? The legal position on these hypothetical issues is not yet clear. In addition, though, it is worth noting that there could be scenarios where ultimately copyrighted work has been used unlawfully to train a GenAI system. A commercial user uses a derivation of the work as a result of the inputs and outputs. The owner of a copyrighted work sues the commercial user in relation to the derivation of the original copyrighted work rather than the GenAI provider. And it may particularly wish to do so if there's a particular commercial rationale or in circumstances where the industry in question is sector specific or niche or small in its size. In a moment, Alex will talk to the mitigation considerations, but first Alex will deal with the potential risks relating to datasets and joint tortfeasorship.
Thanks, James. Yeah, so we're going to move away now from the risks associated with the use of the outputs of GenAI tools and assume for current purposes that the outputs themselves aren't infringements of third-party content because, for example, they don't constitute a substantial reproduction of the third-party work. I'm going to think about the possibility of the end user incurring risk and exposure for IP infringement in relation to the nuts and bolts of how the AI tool works and how it generates responses to the end user's prompts. And in this context, the concept of joint tortfeasorship springs to mind. So for those who aren't familiar or have forgotten about joint tortfeasorship, it's essentially the law which governs accessory liability for torts. Intellectual property infringements are torts, and so the law on joint tortfeasorship is engaged in an intellectual property infringement context. And with any tort, there is a primary tortfeasor. So it's the person or entity which most obviously commits the tort, or in this context, the intellectual property infringement. But there often are other entities which are mixed up with the primary tortfeasor in the commission of the tort. And joint tortfeasorship is commonly used by intellectual property lawyers to get behind the corporate veil and create some risk and personal exposure for people who direct the activities of companies who commit intellectual property infringements. So it's often a way which intellectual property lawyers, particularly litigators, will use to create some personal exposure and therefore leverage, particularly against owners of owner-managed businesses, for example. So IP lawyers are familiar with this concept of joint tortfeasorship, and any IP lawyer thinking about potential exposure in a GenAI context is eventually going to start thinking about potential liability for joint tortfeasorship of commercial end users. So what is the test for joint tortfeasorship? Well, it was relatively recently refined by the Supreme Court in a case in 2015. And essentially, in any context, including an IP infringement context, it's about providing substantial assistance to and sharing a common design with the primary tortfeasor in the doing of the act which constitutes the tort. So just to be clear, it's providing substantial assistance and sharing a common design to do the act which constitutes the tort. There doesn't need to be a common intention to commit infringement. It's just a common intention and substantial assistance in doing the act which constitutes an infringement. So what's the potential application of joint tortfeasorship in a GenAI scenario? I think the answer is it depends entirely on how the GenAI tool works, what assets, what third-party assets the GenAI tool uses, if any, in answering the questions and responding to the prompts of the GenAI user. And I suspect that the majority of people in the audience, and I count myself in this cohort as well, in relation to most AI tools, don't really have a clue how it works under the hood. We've heard details about concepts of training, but are we really clear about what training means in any particular scenario and with any particular GenAI tool? For example, does the training happen during a period of time when third-party content is used to train the AI tool? And then does the AI tool then do what it does subsequently and answer prompts without any reference to third-party content? If so, how does it do that? ChatGPT is an example of a large language model. As I understand it, large language models which produce text outputs are trained in a way which uses third-party content during a training period. And then when it responds to prompts and gives answers and creates outputs in response to prompts by users, doesn't in real time use the third-party content. In that context, it's unlikely that the commercial end user is going to have any joint tortfeasorship IP infringement risk because it's not prompting, providing the inputs and sharing a common design with the AI tool to make unlawful, unlicensed use of the third-party content. But there are other types of GenAI tools which may well, in real time, in response to particular prompts, reference, search, and use third-party content to produce the output for the user. In those circumstances, concepts of joint tortfeasorship do arise. And how much of a risk is this in a commercial context? Again, it depends on the circumstances. So most commercial end users who use ChatGPT are unlikely to be within the crosshairs of competitors who are monitoring whether or not their competitors are using ChatGPT in a manner which might make unlawful use of their content in what the AI tool does under the hood. But when we think about more rarefied, more specific GenAI tools which are used by businesses in niche areas where there is relatively little available content which addresses the issues which need to be addressed, there's relatively little data, it's much more likely, if not now then going forwards, that there will be generative AI tools which will in real time make unlicensed use of third-party sources. And it may well be obvious, depending on the specificity and the rarity of the content in question that the originators and the owners of the IP rights in that content will recognize and realize that the outputs of its competitors must have derived from unlawful use by the AI tool of their content in generating outputs. In those circumstances, as an IP lawyer, if my client wants to cause a significant headache for its competitor, I'll be looking at the prospect of running a joint tortfeasorship allegation, creating some risk and leverage against that competitor. So it's an issue that people need to be aware of. But as I said at the start, to be able to assess these issues properly, it's helpful to know how a particular generative AI tool works. And this takes us on to a very important issue of mitigation of risk and what can be done by end users to minimize the risk of IP infringement associated with their use of GenAI tools. And again, we started off by asking the Bing implementation of ChatGPT about what end users might do to mitigate risk. And it came up with these multiple buckets of considerations in that context. And broadly, they fall into three categories. So there's a category around due diligence. The first couple of buckets are really all about the due diligence that needs to be put into the use of GenAI tools. There's a second kind of category. The next 5 items you see there are all associated really with allocation of risk in the terms and conditions of use of the GenAI tool. And I'll come on to talk about how likely it is that any user will be in a position to negotiate and reallocate that risk. And then there's also the kind of, I guess, common sense, stay updated as best you can with the law. And very kindly, ChatGPT said, make sure you consult with a legal professional, which was very kind of it. But let's look at those things in a little bit more detail and hopefully boil them down into a couple of categories. So firstly, in relation to due diligence, the advice from us would be educate yourselves about how the AI tools which your people use actually operate. Can you be confident that they only use licensed data sets to train and respond to questions so that the risk of infringement of IP in the training data is minimized? What is the allocation of risk in the standard terms? Because most GenAI tools which we use at the moment are likely to be governed by standard terms, which will have allocation of risk provisions in them. What does it say about the allocation of risk? If you're working in an industry, in a business which is looking at or currently using more specific GenAI tools which have narrower scope, then there may well be an opportunity to negotiate as part of the procurement process a reallocation of the risk in the terms and conditions associated with the IP infringement risk. Now, I'm not going to be able to tell you today, certainly in this session, which are the specific provisions that you'll need to look out for, because the reality is that all of these terms and conditions will be written on a bespoke basis, and provisions which allocate risk for IP infringement will be dotted around. Somebody, if interested in working out what the IP infringement risk is and reallocating that risk, will have to go through on an end-to-end basis, identify the relevant provisions and work out the extent to which they ought to be renegotiated, and attempts to renegotiate them should be made. But again, reallocating contractual risk where possible should be borne in mind. Probably more important though than the contractual mitigations are some of the operational mitigations which can be put into place. And the first one we'll talk about is the importance of original input and refinement. So the more obvious or common the inputs put into an AI tool, the more likely it is that somebody else will have already asked the same question and have already got exactly the same result. And so the more likely it is that the use of the second user of particular outputs will infringe copyright owned by the first user which asked the same question and got the identical output. The risk associated with that can be minimized, firstly by trying to be a bit more creative and insightful and different about the initial question, but then importantly, refining the outputs, asking the AI tool a series of further questions so that the output of the AI tool, which ultimately is likely to be used, is refined and refined further and further, and as a result, is likely to move further and further away, both from any other outputs generated by that AI tool in response to prompts from users, and also importantly, move further and further away from any pre-existing material which the GenAI tool has been trained on or which it might otherwise use in providing the output. So original inputs and refinement. Secondly, consider how your business might use AI outputs. Do they need to be externally facing? If so, should they be given some human bespoking beforehand, again, to try to add a level of refinement which reduces the infringement risk? Crucially, think about, if you haven't already, implementing a GenAI use policy. Make sure your people are informed about it. They can easily understand it. They can easily implement it. Some of you probably have these policies already. If you don't, they're coming. From our perspective, these are likely to be a significant work stream for us going forwards. Maybe you want to tell your people not to use GenAI tools at all until the risks and appropriate mitigations associated with them are clearer. Maybe that's not realistic, probably not. So maybe you need to be clear about which GenAI tools your people can use and make sure they only use GenAI tools which you've vetted and risk assessed and feel comfortable with the risks associated with them. Educate your people about how refinement of inputs, iterative inputs to ensure that your outputs move further away from anything that's gone before can minimize the risk. And think about controlling your externally facing use of GenAI outputs. You don't want potentially risky outputs coming to the obvious attention of third-party content owners who may allege infringement. Think about the risks associated with that and what you might do to mitigate it. Final point on the slide, James touched on it earlier on, but it's important to reiterate. It's not about infringement risk, but it's about the risk of inadvertently giving away crown jewels. Most GenAI tools will include a provision which says that any inputs which a user puts into the engine can be used by the engine going forwards. There's a real risk associated with that confidentiality in confidential inputs is accidentally waived. There's also a real risk that there might be some proprietary information which is included in the inputs, which is protected by copyright or some other intellectual property rights, which you as a business don't want to give away for free. So again, be careful about inputs and controlling inputs and ensuring that the policy addresses that. We're going to finish very briefly, very conscious that time is running on, with James giving a brief summary of where we currently are in relation to the legislative and regulatory position in the UK in relation to the management of GenAI related infringement risks.
Thank you, Alex. So in short, the current position under UK law is that there's a copyright exception for text and data mining for non-commercial purposes. Now, there were proposals to introduce into law a broad copyright exception to allow for any form of commercial text and data mining. This was then shelved, and a working group was set up to develop a voluntary code of practice. As I understand it, that has not materialized in an effective code of practice to date. And so on the 6th of February this year, the government published an update and basically confirmed that it would now lead a period of engagement with the AI and rights holder sectors, ultimately to see if some form of partnership and workability could be found. The House of Lords, however, again in a report from February this year, take a very different approach and effectively make the point that it is for the point of copyright is to reward creators for their efforts, and that the current legal framework is failing to ensure that these outcomes occur, and that the government has a duty to act, and it can't sit on its hands for the next decade waiting for the courts to effectively come up with the answer. They say that the government should publish its own view on whether copyright law provides sufficient protection, and that they say by spring of this year, the government must set out its options and prepare to resolve the dispute definitively. There was also discussion in the report about whether there should be a mechanism for rights holders to be able to check the training data, as this would provide assurance about the level of compliance with copyright law, and that the government should encourage good working practices by working with licensing agencies and data repositories to create expanded high quality data sources at the scales needed for large language models. They also discussed opt-out and opt-in systems, and as part of the evidence to the committee, Stability AI popped up and said it already operated an opt-out system and believed requirements to obtain licenses before conducting text and data mining would stifle AI development. Whereas Getty Images, in its evidence, said that ask for forgiveness later, opt-out mechanisms were contrary to the fundamental principles of copyright law, which requires permission to be secured in advance. So there we go. We'll have to wait and see whether the government follows the recommendations by the House of Lords, or whether the Stability AI case goes further to trial and sheds some light on the issues that we've talked about today. Unless Alex has anything else to add, I will pass back to Simon to chair our Q&A session.
Thank you very much, both of you. Fascinating stuff. We've had a few questions, and I think if I group the first two together, because they, I think, approach the same issue, but from slightly different directions, and you'll see what I mean. So the first question is sort of a practical question. Basically, is it the more data and images and text or whatever that your AI tool is trained on, or which either through its training or in real time, produces its output, to what extent does your output have to be substantially similar to the original input for that to be infringement? Is it the bigger the data set, the less likely you'll be able to show any kind of copyright infringement, say, or other infringement for a particular thing? And on the other side of that coin, we've been asked, if a third party is claiming that the organization which has used this tool and produced some material has used a copyrighted photograph, what level of evidence do you need to show that what we did wasn't produced by AI, we produced this from some other means? So some sort of practical questions as to the level of proof, the level of similarity that's needed for this to be as it were, a real worry.
Shall I take that, James? Yeah. So probably easier to answer the first question first, which I think, the second question first, which is more around, I guess, challenging the allegation of a third party that they own the copyright in an existing work which has been infringed by an AI output or the use of an AI output. And the reality is that going forwards, it's going to be increasingly unclear whether or not a copyright work in which copyright is asserted has been generated by a human author or artist or a GenAI author or artist. And where there is a significant or serious question to be asked in relation to that, then it is absolutely within the gift and the entitlement of the parties on the receiving end of an infringement allegation to put the potential claimant to proof of the origin and ownership of the copyright work, in the same way that it's always been within the gift and a frequently trodden path for a potential defendant to say to the claimant, well, if you're alleging copyright ownership, you need to prove ownership, and that requires you to demonstrate authorship, chain of title in copyright, etc., etc. And that's an area which may be complicated by the terms and conditions of use of AI tools, etc., etc. So it's an area which is already and has long been the subject of disputes in copyright infringement and other intellectual property infringement claims. But GenAI introduces a further level of uncertainty and potentially complexity, which creates risk and arguably opportunity for both parties in trying to resolve those disputes. In relation to the question about the degree of the degree of substantiality which is required between an output and existing third-party content for there to be an infringement, and whether or not the quantity of third-party content which the AI tool has been trained on is likely to result in it being less likely that the output will infringe. I think the answer to that is it probably depends more on what the inputs are and the questions, the prompts from the user. Because if the user's prompts are very specific and an AI user has a particular pre-existing artwork in mind, for example, and it wants GenAI to produce something similar but a bit different, then it's not going to matter if the GenAI tool has been trained on all the artwork in the world. If the prompts are so specific that it's inevitably going to produce some output which is very similar to an existing work, and where it does produce something which is very similar to an existing work because the prompts from the user was so specific that that was the inevitable outcome, then the expectation is that if the output of that that output is used in a manner which is likely to come to the attention of the copyright owner is going to say the image and think, that's mine, that's an infringement, however it's happened. I'm going to take whoever is now using that output to task and allege infringement. And in those circumstances, the test, whether or not there is infringement, will be the same test as it's always been under current legislation, unless until that changes, which is whether there has been a substantial reproduction, either qualitatively or quantitatively, of the original copyright work. I hope that answers the question.
I'm sure it does. A couple more questions again, which touch on related areas. So one person has said, could we expand on the risks of staff using their own personal account on a GenAI tool, but using that personal account during work time and for work purposes, and potentially that staff member potentially in breach of any policies that organization has in place, putting commercially confidential information into that input? If that individual does that in breach, what are the risks around that? And I guess a sort of related question, one person said they work for a research think tank and their academics use ChatGPT and similar and incorporate the outputs from that into reports that they produce, and how should that organization mitigate risks around and disclaim risks of when sharing those reports with third parties, with disseminating that output more widely? So yeah, risks around the use, whether legitimate or illegitimate use by employees, contractors or whatever, of using these tools in the work context and mitigating those risks.
Yeah, so I guess there's two perspectives there. There's firstly there's the IP infringement risk. Can the employer, or is the potential liability for the employer if the employee uses GenAI tools in a manner which constitutes an infringement? And then the flip side, what are the risks associated with employees inadvertently disclosing or using confidential information when they're using GenAI tools and then potentially inadvertently giving some crown jewels away? So in relation to the first of those, the IP infringement risk, whether or not the act which constitutes the risk is the act of the employee, which is then attributable to the employer, will be fact specific, will depend on the circumstances in which the employee has used the tool, and I suspect whether or not they're acting in the course of their employment when doing that. Where an employee goes rogue and goes on a frolic of its own, the employer is also always going to look at a basis upon which they can say the acts of our employee in these circumstances were not the acts of the employer, and the employer shouldn't be held liable. But I don't think there's an easy or simple answer which is a blanket answer to whether or not the employer will be liable in those circumstances. The most important thing is trying to make sure that there's a policy in place which employees are aware of, they can easily implement, and they can comply with, they know how to comply with, to minimize the risk of those more thorny issues ever having to be resolved. In relation to the flip side, this sort of risk of employees inadvertently giving away crown jewels, disclosing confidential information when they ought not to do that, that's very difficult, because whether or not the employee is acting in the course of their employment, if that information has been put in the public domain and has found its way into the public domain, then whether or not confidentiality in that information has been lost will depend on the circumstances in which that information is received by the recipients. And if the world at large gets access to that information as a result of inadvertent, accidental, or inadvised disclosure, whether or not with the approval of the employer, if the recipient isn't aware when it sees that information that it is subject to a duty of confidence in relation to that information, and the likelihood is that it won't be because it is receiving this information as a result potentially of its use of a GenAI tool, or several steps of disclosure further on, which has led this information to come into the public domain. There's no way of putting that back in the box and restoring the confidentiality in it. So again, the important thing is to mitigate the risk associated with the inadvertent disclosure of confidential information, with the inadvertent giving away of any crown jewels, by making sure employees know what not to do.
Yeah. And I think one final question, which hopefully we've just got time for before we wrap up, how protected might a user be by having a license through one of the license schemes you talked about? To what extent does that protect you as a user from being sued by someone in due course?
So a license or consent to do the thing that you're doing, so a license or consent to use existing content in the manner in which it is being used, will provide a complete defense to any infringement claim. The issue will be in determining, firstly, what the scope of the license is, and secondly, and probably most importantly, whether the subject matter, whether the particular content in question falls within the scope of that license. And again, that's all part of the due diligence mitigation aspect associated with the use of GenAI. And I don't and won't suggest that conducting due diligence on these tools is easy. I don't suggest that it's, you can quickly and easily find out whether or not a particular GenAI tool is properly licensed to use all of the content it's been trained on, and potentially any content which it uses on a real-time basis to respond to prompts. It's not the sort of information typically that a GenAI tool provider is going to shout about, unless, I suggest, it is confident that it has got all bases covered and all the consents it wants, in which case, if I was a GenAI tool provider, I'd be shouting from the rooftops about it. But yeah, due diligence on the scope of the license of the tool to use the third-party content it has used to provide the outputs to its user is key.
Fantastic. Thank you very much. Well, that's all the questions I think we've had through the Q&A. So thank you for everyone. I'm sure if you have any further things that occur to you after the event, then do contact Alex or James. Their QR codes for their LinkedIn were on the first slide. So when the slides come round, you'll be able to get them that way. You can easily find them via our website and email them there. I hope you found it interesting and useful. I think we've got just a slide about our next seminar coming up. No, before that, feedback. Hopefully you enjoyed it. I certainly did. I'll give positive feedback. But if you can complete the survey once, that'll be made available to you once this webinar ends, that would be tremendous. And let us know, of course, what topics you'd like to hear more about, because we want these seminars to be useful and relevant to as many of you as possible. In terms of the next one, the invitation will be coming out shortly. So this is an insolvency related one about how to help your organization maximize opportunities to buy businesses out of administration. And our colleagues will be giving some useful tips there and thinking about some risks and pitfalls. So if your organizations are ever involved in those sorts of acquisitions, I think that's a must watch, a must listen. But I think that is all. We may have just had a couple of a bit of very positive feedback from people via the Q&A. Thank you very much for that. Praise gratefully received by whatever means. Thank you very much for your time in attending. Thank you, Alex and James, for that fascinating talk. And we hope to see as many of you as possible in our future seminars. Thank you very much.